Welcome, sir.
Paul, good to see you, man.
How's it going?
I'm good. Yourself?
I'll take your seat over there. Great.
Great.
Okay, so it looks like it's all over now.
Let's see what happens.
So for you as a lawyer and academic lawyer and a lawyer who writes and has a platform, a digital platform, is explaining the law to other people. Is this the end of the road? Is it a good trial? Does it give a good image to the judicial system in Ghana?
I think it does. First of all, you say kudos to the team. These things that we see is often things that goes in terms of litigation. They have acquitted themselves, and all and sundry can acknowledge it. In terms of what will happen, there's a last route available to the petitioner if he so desires. That's to seek a review of same if he so desires. And maybe it might be an option that they might be willing to take, looking at how they have conducted themselves in terms of when rulings are given against them. They always exercise their right to seek a review. So we'll see whether they will exercise that right to seek a review. But it also, affirms Justice Atugbe's position in 2013 when he said, as part of his judgment, that the court sparingly, annuls election results as compared to maintaining them in the light of public interest. And for that matter, if you seek to go to court, there's a huge burden on you to be able to overcome the presumption of regularity that goes with it. And this also reveals certain aspects which I think is also good for legal jurisprudence in terms of video testimony, where the PW3 testified via video testimony. And some of us hold the opinion that video testimony can be used in other parts of the country in which there's internet penetration, but there's lack of infrastructure over there for people to testify. So, I think there are lessons to be learned from this process. And I think it was a good judgment, in my opinion, looking at how the court took its time to assess the truth from the issues, as compared to 2013, where one of the criticisms against the court was that they didn't touch on the issues that the two main issues that the court brought up. This is an instance where the court took its time, answered from issue 1 to 5 in details, taking into consideration all the testimony that was before the court. So for us, it gives us an opportunity for us to deliberate upon it. There are certain challenges that other people will raise, but we are waiting for the certified judgment, and once the certified judgment comes, we'll be in a position to compare and contrast what happened.
For you as lawyers, is it important, or is it a point to note about the Jean Mensah controversy, that there were court procedures that were exploited to have her not to appear and to mount the witness box? For journalists, it was something they were looking forward to. We had set the stage, we had designed graphics for it. Here we designed graphics for it with Chachu Chikata on one side, Jimenez on the other, with a flame of fire in between. And we said the ultimate cross-examination is going to happen next week. Never did. Lawyers explained to us that it's a procedure that lawyers are quite familiar with. For you as a lawyer with a public interest, what do you have to say about that?
What I always want to say is that people should consider what was before the court as against what they know outside of the court. And that's the biggest challenge that you have. An instance where maybe within the NDC foot soldiers, among the NDC foot soldiers, among people who are part of the party, they were aware of, let's say, multiple infractions on the part of the election, or on the part of the Electoral Commission. They are aware of so many things that happened. But I will always urge people that for you to understand it better, you need to understand the case that was brought before the court. And as part of the case that was brought before the court, lawyers use the various tools that are available to them in terms of strategy to make a determination of sin. And I always say to people that, are you aware that if Mr. Tony Lita did not have a valid license and had signed that document, the entire petition would have been thrown out? Are you aware of that? Because the law says that the lawyer must have a license to sign it. Are you aware of the fact that if, for instance, in terms of Tony Lita
so that
signing,
if the case had begun before that information was made available to the court and it was verified,
yes,
the case will end right there?
Yes, it will end right there. That if you don't have a valid license, the law does not allow you to sign a legal process. Even when you have a valid license, but you make a mistake. And in terms of writing Akoto Ampao, but you endorse on it Akufo-Addo Prempeh Nku, the law says that process is a nullity. That is the law. That is something that in terms of procedure we are used to. And all of us are very comfortable with it. But however, imagine in this petition, there was that mistake. And an instance where, that never came up because none of them made it, an instance where a lawyer signed a document and they don't have a license for that legal year. And the court was telling you that based on the law, your petition is a nullity. How would have Ghanaians reacted? But that is the law. So people should understand that the law as has been passed by Parliament, anyway, the court is a servant of the law and being applied in the courts. There are certain aspects of it when it so happens. So somebody walks to a lawyer, he does not ask for the lawyer's license. The lawyer prepares a process. The Supreme Court has ruled in Terewaja, among other cases, that process is a nullity through no fault of the client. The client took his case to a lawyer. The lawyer made a decision. That is the law. So there are instances where I always tell to my friends who maybe based on politics, they might want to take one, that in terms of the position of the law, can a party be made to testify? If not for the election petition, in ordinary course of litigation, can you compel somebody else to testify? If the answer is no, has the court erred? The court makes an, and remember that any decision that the court makes has an influence on other court, because apart from it being a Supreme Court, it's also a policy court. So one of the issues that there was a big issue as to when does a witness statement becomes evidence. Before the decision came, the Supreme Court has made a decision. However, in other courts, when people filed witness statement, at case management, objections were raised. But this is an instance the court said that the only time the witness statement becomes evidence is when the person has gone into the box and the court seeks to admit it, and after objections have been raised or not, and it's tendered, then it becomes evidence of the court. So the court as a policy court has also given directions in terms of it affecting other courts, and so it's also a good guide for all of us.
Yeah. But does it not make a difference that it's an election petition that is being broadcast on television? And therefore you have invited the court of public opinion to pass comments on it. And so you would have to respond to the court of public opinion as well as the court of law.
You see, by reason of our constitution, court hearings are supposed to be held publicly. Mm-hmm. For COVID protocols, we have reduced it. And for that matter, justice emanates from the people. The justice belongs to the people. The people have a right to see what happens in court. To the extent that, in terms of cases that are happening in court, it's pasted on the notice board in terms of court, the course list. So you can easily walk to court and sit throughout the hearing. Okay. However, in terms of the public opinion, sadly, the court cannot look at public opinion. The court has to look, if it's not issues of policy direction of the court, but have to look before the evidence before it. And when it's purely adversarial, then the court, in terms of people having an interest, and in terms of the evidence that the court has to evaluate and come to that decision. I'm sorry, we might have a different opinion, but sadly, what the court can look at is not what is happening on the news or what everybody demonstrates that is happening, but rather the evidence that has been brought before the court. So if you might have other evidence that you thought could have propelled your case, if you don't bring it before the court. So I often say that the court is not there for the truth, but the court is there for the evidence. What is the evidence for the court? What is the evidence that determines the truth of the court at the end of the day? So the TV might, public opinion, of course. However, the court cannot use public opinion and basically disregard the evidence that is appearing before the court.
So this is going to be a debate for a long time to come, because in his speech tonight, President Mahama made reference to it. He talked about the protectionism that the NDC have alleged against the court itself and against leading counsel on first and second respondent, that they were protecting the electoral commissioner.
Paul, he who loses have a lot of things to say about our justice system, and it's not strange from it coming. What I will be glad is what happened in 2013 after the result. We had academics sitting down to critique it, and that's what we are hoping it will come out, where academics from both sides will make their position clear. There are certain people who have shared opinion about the position the court took on some of the rulings that it came out with. But at the end of the day, I expect for more discussions based on legal authority, legal opinion, and people should not be emotional about the decision of the court that has been made.
The court also singled out a discussion of PW1.
Yes.
The petitioner's witness 1, yes. Johnson Adjei Dwomoh. Is that also part of the process? I mean, people thought the court was being petty, calling out his name and saying that he has admitted certain things, and based on his own admissions that the petition ought to be dismissed because on the figures he has admitted this and that. Is that normal?
No, it's very normal. If you read any standard judgment, the style that they rule the judge is very standard when it comes to judgment that has gone through trial, where the court will give a background of it to state what the person said, what all the parties in terms of their pleadings, decide to go to the evidence, evaluate the evidence, come to the issue, rule on the various issues, comes to a conclusion. So that is a standard judgment that the court gave. And in terms of analyzing the evidence, in terms of analysis that the court will make, and remember that before the court made those analyses, all the parties were made to write their written submissions. And in their written submissions, all of them have made analysis based on the various evidences that was presented before the court. And on that basis, the court can decide that based on this is our reasoning, and this is how we intend to go. So what happened in terms of making a reference to PW1, PW2, PW3 was very normal. And in terms of the words that were used are something that you usually find in every judgment that the court writes. And some of us will be willing to open it up for people to see how the courts have written over the years. And in terms of the court having unanimous, I realize that people have a lot of statement about the unanimous decision. That has been the practice of the court for a very long time now. For the past 10 years, the court has, after the election petition, where you saw a diametrically opposed court, after that, most of the decisions of the court has been unanimous.
Most of the Supreme Court decisions after 2013.
After 2013 election petition, I'm saying that the last election petition where you saw a real dissenting opinion of 5-4. After 5-4, we have not had a situation where it was so close. Like most of the decisions of the Supreme Court, if you review it for the past 5 years, a lot of unanimous decision of the court. So that has become the practice of the court, an instance where the court decides to build consensus in making a decision that is made. And it's also the practice of the court, unless the senior most, who is the presiding judge, decide to allow a colleague to read. It's very normal that when chief justice sits on decisions, the chief justice often, especially of a case of such magnitude, the chief justice will give his opinion. So people should not be concerned about the unanimous decision. People thought it's more like goals, so let it be 6-1. But if you decide to look through the case law of the Supreme Court, unanimous decision of the Superior Court is very normal.
But apart from that, there were several decisions that went against the petitioner. Almost every decision went against him. Application for interrogatories went against him. Reopening his case went against him. The subpoena, reopening to subpoena, Jane Mensah went against him. He lost the review applications on those of these that went against him. Mr. Chikata lost almost everything.
Not at all. He won some application. He got an amendment, which the court willingly granted.
And they granted that unanimously as well?
Yes, unanimously. He got an application for extension of time to file his written submission, unanimous too. After he filed his witness statement, 2 witness statements, after the court ordered him, he made a prayer. The court unanimously granted for him to add an additional witness. He prayed an instance where, because the witness who was supposed to come into the dock, because of certain health concerns, he prayed for self leave for the witness to testify by video evidence. The court gladly granted it. When it came to the objection to the witness statement, when Kotoampa raised several objections, almost about 20 objections to about 20 pleading paragraphs, the court disagreed with most of them. So that is what happened. That's what happens in court. However, it's very sad when we start to look at it from a goals point of view, like he has scored 1, he has scored 2, he has scored 3, without looking at the issues before the court and the argument that parties made. And I think that it will be better when we decide to have a discourse where we look at the argument, we look at the issues, than to be striking it at 1-0, 2-0, which most people would do.
I see. Are you preparing to write a book about it? Should we invite you for a seminar and talk to young people about it?
Let's see how it goes. We hope to see. We have gone through it. I think with the team we will decide on the next step we will take.
Get to Dennis Nuggets and read the Nuggets of Dennis.